The opinions expressed on the Custody Queen Show are for informational purposes only and are not a substitute for personal, professional legal advice. The persons discussed are fictional and not based on actual clients.
Thought it was love, had kids in between. You can count on us, we're the Custody Queens. Yeah, you can count on us, we're the Custody Queens.
All right, everyone. Welcome back to another day of CQ Radio. I'm Sam McBride. I am here with my lovely and favorite blonde, Kristen Holstrom, and we're welcoming a very special guest today, Lionell TJ Tillman.
How you doing?
Welcome, Lionell. We're super excited to have you.
Yes.
Likewise.
So welcome. And we've been excited about this episode for quite some time, just so that all of our fans out there kind of know a little bit of background about Lionell. He is a passionate advocate and thought leader. He has taken a bold stance on the complexities of the child support system through his insightful ebook, How I Stopped Child Support Legally. Drawing from his own experiences and extensive research, Lionell sheds light on the often overlooked issues surrounding child support laws and the impact that they can have on families. His insights challenge the status quo and provoke thought on how these systems can be reformed or benefit for all involved. Join us as we dive into the important conversations today and explore Lionell's perspective on the topic and how that affects countless lives. Welcome again, Lionell.
How you doing? Thank you for having me.
Well, that is quite the introduction, and I've actually, checked you out myself, and I was intrigued with parts of your ebook. I obviously haven't read the whole thing, but I've definitely read snippets and learned about you. And I think that you have, with your experience of going through it personally, I think you can shed some light onto the whole issue. And, I personally think there's a lot of issues with child support, how it's handled, but I don't write the laws. And my job is usually the one advocating it. But I think you do bring light to a lot of issues with child support. And in my honest opinion, it needs to be relooked at, and everybody needs to go back to the drawing board.
Yeah, I concur 1000%. For those, my name is, as you stated, my name is Lionell TJ Tillman. I'm the author of How I Stopped Child Support Legally. Ultimately, unfortunately, I had to represent myself without any legal background in a 2-year hearing against child support in the county of Los Angeles, and ultimately got my case dismissed for extrinsic fraud after 22 years.
Wow, 22-year long journey. Wow.
Yes.
Can you tell us a little bit about the background of how the child support case was initiated? How did you get that order against you? Kind of start from the beginning and walk us through it.
Okay. So the order was started due to the Title 4A, the government assistance, the cash aid, the Medicaid, and the food stamps. I found out about my child support case 7 years after it opened. So I was on child support for 7 years and didn't even know it.
You weren't served with any documents, or?
Not at all. They allegedly served some documents, but what we found out in our hearing, they did nothing of the sorts. When I found out about the case, it's payday. I just started a new job. I'm maybe about 6 months in, and HR, sends me a request, said they want to speak to me. I go in to talk to HR. They say, hey, we got an income withholding order. And I'm like, well, what is that? And they said, well, yeah, they're going to start garnishing your checks effective immediately. I'm like, who's going to start garnishing my checks? And she handed me a letter and it says child support. I'm like, child support? What do you mean child support? She said, I don't know, but here's your check. And I'm looking at my check and it's short. So I'm not doing too good at this time. So I need every penny.
Right.
I contact child support services, and the representative on the phone tells me, well, Mr. Tillman, it's your response is untimely. There's nothing that can be done. I'm like, what do you mean there's nothing that can be done? You just sent me this letter. She said, yeah, well, you've been on child support for 7 years. You had 6 months to respond. I said, wait, what do you mean I've been on child support for 7 years? She said, yeah, it's been 7 years. You had 6 months to respond pursuant to California Code, something. Your response is untimely. You may want to go to the courts. I go to the courts downtown LA, and I speak to the family law facilitator. She looks at the case. She says the same thing. Unfortunately, you had 6 months to respond. There's nothing that can be done. And I went under that misrepresentation for another 13 years.
Wow. And so what motivated you, or what was the change that made you kind of relook this and say, hey, I'm gonna move forward with trying to get something done?
Right. So during those 13 years, they started suspending my driver's license. And once they suspended my license, after a while, I'm still driving on, and now I'm getting a suspended license. And ultimately, I believe it was in 2011, I actually was incarcerated for 30 days due to driving on suspended license 4 times due to child support. So at that point, I said, okay, I need to fix this because I can't go back to jail because the judge told me, if you come back, you're doing 6 months. I said, I'm not doing 6 months in jail for a license. That's not going to happen. I contact child support and they say, well, you can enter an agreement with us and pay us an additional $50 on top of the money we're already taking, and we'll not suspend your license. But every year, my license got suspended for a system error. Um, Again, this is 13 years go on of this, and just this particular year, I'm just frustrated because if I'm paying you an additional money so you don't suspend my license, why is my license getting suspended once every year? I have to call you back to reinstate my license, pay you another $50, then pay the DMV another $75 to reinstate my license. And now I'm just speaking to the lady. I'm like, man, I don't even know why I'm going through this anyway. Like, this is fraud. Like, what are you guys doing? And she said, fraud? What do you mean fraud? You got served. I said, whoa, that woke me up. I said, wait a minute, I got served? She said, yes, you got served. I said, well, tell me what day did I get served? Because I've been with me every day of my life and I know we didn't get served.
Right.
She says, hold on, I'll tell you exactly what day you got served. She comes back. I'm sorry, Mr. Tillman, we do not have your signature. I said, well, I know you don't. She said, well, that don't matter anyway because you volunteered into the program. I said, I did what? She said, yeah, you volunteered and we had your signature. She placed me on hold. She comes back. I'm sorry, Mr. Tillman, we do not have your signature. So from that point, I knew that I was supposed to get served, and I knew that child support was voluntary, and that they said that I volunteered into the program. So from that point, I just started doing more research. What else are they supposed to do?
Yeah, and I think that, thank you so much for sharing your story. And I think it brings up a lot of really important points. Um, uh, most notably, the fact that service was not initially effectuated. And unfortunately, that happens. It's not actually that uncommon for people to move forward with fraudulently claiming that a person or an individual was served. And that's part of what makes your case so tragic initially, but then so hopeful after that. And I just, in thinking about it, it brings up to me a huge point of taking kind of a proactive stance in your case. Whether you have an attorney or you don't have the means for an attorney, you can certainly still consult with an attorney to truly understand and educate yourself regarding your rights, because a lot of times the system and or just the way the legal process works, it's sometimes prepped for us to feel that just naturally that's just how it is, and
Right.
it's not true. So that brings up a really interesting point. Now, does this mean that everyone could do the same or similar thing? I don't know, because your facts are so specific to you. And, there is a child support laws, as Kristen put in, kind of mentioned at the beginning. And the laws are the laws. And if service is effectuated and you have the notice and opportunity to respond and participate in the case, then, you have access to justice. You can inform the court your position, whether or not you're objecting to paternity, whether or not there's information that the court needs to know about your income, things like that. So it's a huge cautionary tale. And, again, I think it's great that you're bringing light to this. And I really do think that the huge takeaway, although there are many takeaways, is to not just accept that the situations that you're provided with need to or are remaining the same. In your case, you ended up being successful a long time later, and hopefully with some sort of knowledge and additional experience for all those listening to this, they can kind of say, hey, we might need to reevaluate some things, even if it's not child support related, it's service related, or there's an order you maybe don't agree with, or you feel you didn't have a right to be heard to. There may be some things that can be done.
Yeah, most definitely. And Oh, you was gonna but I was gonna concur, most definitely in regards to, because there's what I also found out. Not only with service, they have specific procedures that they must follow when opening these cases:
Mhm.
the summons, the complaints, the proof of service, whether there's a default or not, and the actual judgment. All of these documents pursuant to, and this is not legal advice, just my experiences with child support, 28 USC 1691 says that all writs and processes issued in these processes must be under the seal of the court and signed by the clerk thereof. What I noticed is my proof of service, it was completely blank. It was never filed. My complaint, it didn't have any signatures on it at all. It was just filed. And we know that these processes, we now know that they work under presumption. So if we presume, if you don't, like you said, if there's no challenges, there's no objections, we presume that you agree. And I always get this word wrong. Some people say it's prima facie.
Prima facie.
Right, exactly. So that says that the court's taking whatever is true and correct until you provide evidence to say that it's not. So until you challenge it, we're taking it as it's true and we're presuming that you agree because there was no objection.
Yeah, and you have to think DCSS probably has thousands and thousands and thousands of cases. And while they can be beneficial to some people who can't, afford and they need someone to be able to kind of navigate them in the system, it's a very robotic system. It's not unique to your circumstances. They are making a lot of assumptions that when they order that proof of service be served and filed, that it was done. And unless someone is pushing back on them, and there are different requirements when service needs to be personal or when service can be verified through the mail and an address verification could be sent. There are different requirements for different issues throughout the case. But you're 100% right. A lot of times, if nobody challenges and says, okay, well, I know I wasn't served and you mailed it to an address that I haven't lived at for 6 years that is not, on the court's website. If people don't challenge that, they're almost ratifying the ineffective service because they don't ask questions, they don't challenge it. And everyone listening, I want to just make one big point right here is that even if you are not on state aid, the person, that has the child 100% of the time, or say mom has the child one time a month or every other weekend. If any party goes on any sort of state aid, food stamps, welfare, anything, the state aggressively, more so than any other cases, goes after the parent that has the paycheck because they want to recover their money through the state. And so people don't realize that. They're like, well, I was never on state aid. I was never doing anything. It's not you. It's the other party. Even if you have 95% custody and visitation, they're still going to aggressively go after you for that 5% because the other parent is on state aid.
So I have a quick question in regards to that.
Yes.
So when we're talking about the state aid, when we're talking about Title 4A, today we now know it as the TANF program, Temporary Assistance for Needy Families. When we go on their website, it says that it's a block grant. So my question is, what is a grant? A grant is a gift. A gift is something that's given without any counterbalancing payment. So go ahead.
Yeah, well, I was gonna say, I think Lionel, you're certainly right to question whether there's a grant, what laws are currently in place, and challenge those things from Kristen and I's realm and from the attorney realm, where we're focused on ensuring that we're playing within the current rules as they stand, even if we disagree with them. The important thing for us, or what we focus on, is making sure that there is that true access. So when you're kind of going into, you were mentioning your summons and complaint, for all you listening out there, that you're starting a case with those documents, whether you're starting a divorce case, a civil action, a child support case, that's the starting point. And what is so crucial is that information is, a summons and complaint needs to be personally served on the party that they're seeking orders against. And that's your notice and opportunity to respond. So if you don't get to do that, either because of ineffective service, which is what happened in your case, or because you were served and you decided not to respond, then the other side can move forward with what's called a default, which means the case goes on without you. And so in your nightmare situation, which I feel very bad for, but I am so glad that you got out of it. You weren't provided with that notice or opportunity to respond. So you can't respond and say what's going on. So I can't really speak to what changes specifically I would make to the child support scheme. I certainly would probably have a lot of commentary for a lot of family law codes and things in that. And I think that everyone is right to look at and challenge those laws and challenge why we have them in place so that our legislator and lobbying can change those things. But just in our realm, what's so important to Kristen and I, and it should be important to everyone, whether it's a family law case or a civil case or a criminal case, is just making sure that you are provided with your right to be heard and to have the court make those rules.
So burying your head in the sand is never the right answer. It is never.
Never.
I know so many people kind of, and sometimes I do it myself, not dealing with like court documents, but you feel anxiety, you feel stress, and it's easier just to not deal with it and push it away. But with any legal case, that is 1000% the wrong way.
Yeah. Go ahead.
Well, and I said, and this is something that I educate on is, my exact words are, the worst thing a person can do is not show up, because they love default judgments. That's easy peasy. We love it. Don't show up, because now we get to move forward, like you said, with everything that we want to do. And now you're saying, because I speak to a lot, of men, and they saying, well, I didn't sign anything, I didn't do this, I didn't do that. And as they're talking, I say, it sounds like you got a default judgment. Have you ever been to a hearing? No. Bingo. That was the problem.
And what's even worse with the default is if you're not providing your own documentation, if you have the other side feeding DCSS saying, oh, they just bought a new boat and they just bought a new house, and I know that they're rolling in cash, and look at their Instagram, I think they're making 20 grand a month. If you're not providing information to the contrary, supporting your current financial situation, the court has the ability to use that number as income.
Of course.
And it's important to also note that there are specific timelines associated with your ability to participate in a case. And Lionel would be somewhat of an exception to that based on the fact that it sounds like it was set aside for fraud. So there's a different statute of limitations associated with that. But if somebody truly took your default and you lapsed your opportunity to respond, you may still, for a short period of time, have a potential to set aside and be a participant in the case, but it's not a forever thing. So you want to make sure that you act as fast as you can. And I could not agree with Lionel more in that, the worst thing you can do, honestly, is not show up. And I think people think, well, if I don't participate, then I'm not consenting to participation. And unfortunately, that's not true if service was effectuated. It's a somewhat of a nuanced area. And Kristen and I spend so much time talking about custody, visitation, children, things like that. But we don't always talk about the procedures. And that's why I think, and I'm so grateful for you to be here, it's a really great tool to educate everyone about. And it's why Kristen and I always try to push with Custody Queens how important it is to know the law, especially as it surrounds your facts and how your facts play into that and what your options are to do with that to be an active participant, whether you have an attorney or not. You can always reach out and get consults with attorneys. Kristen and I do consults. If you have any questions, you can certainly give us a call, and we can go through a consult with you and kind of go through the intricacies of your own case. But even if it's not family law related, there's plenty of attorneys out there that will jump on the phone with you for 10, 20, 30 minutes and tell you what you can do and give you a little advice moving forward.
Yeah, most definitely. And in regards to custody, and I also, this is something, and I'm very big on that, and this is something that I educate men on. For me, it doesn't matter where I am in my child support hearing, I'm going for joint physical custody, because it is our God-given right. If you don't invoke those rights, they're presuming that you're waiving them. And I'm sure you see it all the time, to where there's parental alienation, or whether a person saying, well, I don't spend that much, I don't get to see, I'm paying, but I don't get to see my kids. Have you went to family court to invoke your rights to demand joint physical custody? No, I haven't. That's the problem. And unfortunately, people just are scared to actually go and deal with these situations head on. And I just educate them. So is part of the education, it for me, it removes the anxiety, because if you know the procedures
Mhm.
and you know what your rights are, then I'm just going in here asking simple questions. Did you follow your own procedures? Yes or no? Am I guaranteed these constitutional protections? Yes or no?
Yeah, no, and that's a great point. And I think especially kind of switching gears to the custody visitation portion of it, you have to start somewhere. And that's the truth, is that, the family code does not favor women. It doesn't. Joint physical custody really is the standard, short of a safety concern. And there's a lot of deviations from that, and things to consider: the status quo, stability, distance between the residents. There's a bunch of factors that go into it, but you have to start somewhere. So if you are in a situation where you feel like you're alienated, or you feel like you're not getting the time that you want, we certainly want to encourage parents to mutually co-parent and both raise their children. You have to start somewhere. So sometimes you may go to court and you may not have had that access, even if unfairly, to your child for a significant period of time. And maybe the court isn't going to give you joint physical custody at your first hearing, but your family law court case is going to stay open for years and years and years. And hopefully you don't have to go back a bunch, but you can continue to progress and try to step up from that plan and get you to where you need to be. So if it seems like, well, I just have no hope, and they're going to have this big attorney and I'm not, and I just have that's not true. And I agree with you. You have to get in there and you have to let the court know your facts, because if you don't ask, more time's going to go by and it's going to be harder to do it later down the line.
Most
And
definitely.
people don't realize that just because there's a child support case through the Department of Child Support Services, that does not mean there's custody and visitation orders. It doesn't mean that at all. So people say, "Oh, I have a case. I have it opened. I've joint legal, joint physical," and then you find out there's just the child supporter. You have to file in the family law court for custody and visitation. You have to. And even I am a big believer that even if you're co-parenting well and you have an agreement, memorialize that agreement in a court order, so that way you have a fallback. Because I have so many clients that co-parent so well, but there are factors that come up: new boyfriends, new girlfriends, new weddings, a child becomes a teenager and it might be tough at one home. It's always good to memorialize that with an order, so that way you have it memorialized, you have a fallback. You guys can deviate as you see fit, by sending a text memorializing the agreement. But if you don't have anything, and mom gets really upset that you have a new wife or you have a new girlfriend, and she's going to take Saturday night because she's pissed. Well, guess what? If you don't have those orders, you don't have anything to fall back on. And more importantly, nobody can help enforce orders that don't exist.
Yeah. And also, just to kind of add to that point, when you're going through a child support case, not everyone does this, but gamesmanship is not infrequent. And if you don't have underlying custody and visitation orders, they're going to use your approximate timeshare. And if the person asking for child support is controlling how often you see your child, that can have an effect financially on not only how much you pay, but it can also be a motivating factor in sort of preventing you from having that relationship. So if you are concurrently, or at some junctures as soon as you can, filing something to get some actual orders in place, those orders can be enforced, which means your timeshare variable, which is used for child support, is changed, which changes your financial obligation too. So they're separate issues, but they do overlap. And I do believe it's important to know that they overlap, so that you can understand how one issue may be really affecting both.
All right, we are running out of time.
Okay.
No, Lionel, finish what you were saying, and then I want to just make you feel uncomfortable for just a minute, because on the custody.
Okay. In regards to them overlapping, and this is something I educate people on as well, because I see it all the time. People make mistakes. They may be in a custody hearing talking about child support issues, or vice versa. You're in the wrong venue. And typically they say, well, I hear you and you may be right, but unfortunately that's not why we're here today. So because they can't give you legal advice, but they're telling you you're in the wrong venue.
And that goes right back to the point. That's back to the point we made the whole kind of show is it's your notice and opportunity. So if you want orders for custody, visitation, or support, you have to file that motion, put the other side on notice. That's what you're asking for, so they have an opportunity to respond and the court can make an order. That's why when you show up at a hearing and you say, hey, I want an order on this, and you never told the other side, the court says, I can't help you.
Right.
And also, it's just not a good look to ever miss. In my opinion, it is never a good look optic wise to go in to a custody hearing and demand support. And strategically, 9 out of 10 times, I will not check that box for child support until I have a custody order. And sometimes if I have a client that's on super limited funds, then I will make an exception here and there. But I just think you diminish so much of a powerful argument going in on how dad should have 50% and we can exercise 50% and the work distance and the home life, it can be maintained at both households. And then the second you start bringing up support, I think it really, really diminishes the powerful argument that it's solely about custody. But that is something you should always talk about with your attorney on how strategically, how do we attack each of these issues. If you have any questions about anything that we have talked about here today on Custody Queens, you can call us at 1-800-419-7772. You can also email us. Our website is custodyqueens.com. But Lionel, I cannot let you leave without making you a little bit uncomfortable because I love it. And I'm going to go a little easy on you because I'm going to go back and read the rest of your book. So you're first tell our listeners how they can follow you on social media and where they can find your book.
Everything is simple. It's childsupportisfraud.com. That's on YouTube, Instagram, or childsupportisfraud.com. And a point that I like to make every time I mention that, I always like to tell people, I do not advocate for any parent to not take care of their children. I advocate for both fit parents to have equal time if that's in the best interest of the child.
Safety concerns, I agree with you 100%.
Of course. And I just I educate people to ensure that there's fairness, consideration, and for people to take accountability as well at the same time on both sides.
All right, Lionel, in what way are you too hard on yourself?
What way am I too hard on myself? Everyone likes it to be perfect. And this is something that I'm big on myself is just get started because you'll figure it out along the way. As long as you continue to wait, you're still going to be one day behind. So it's just get it started and you'll figure it out along the way.
Yep. I agree with you. And I think Sam and I are the same way, that I think I'm really good about giving everybody else in my life grace and patience. And I am so incredibly empathetic. But when it comes to me, I am nothing sometimes but a failure repeatedly. And then I have to remind myself, give yourself some freaking grace, Kristen.
Right.
All right, we are officially out of time, and we'll make sure we put all your contact information up on our social media so they can reach you, they can contact you, they can get your book, they can ask questions. And it was an absolute pleasure to have you on, Lionel. For everyone listening, thank you so much for joining us today and every Saturday here on Go Country. You can reach us at 1-800-419-7772. And Sam?
And remember, let love rule.
Thank you for having me.